I'm Janet Peters, Vice Chancellor for University Advancement at Ottawa University.
And I'm Derek Chappell, Leadership Gift Officer at Ottawa University.
As we talk about New Year, New Possibilities in the OU Forevermore campaign, we thought this would be a good time to share some information about estate planning.
We noticed some of you this may be an area you've never thought of. For some, you already have. But we thought the beginning of the year is a good time to share this information for you and with you.
We are planning this to be a two-part series. Today we're going to be talking about goals of estate planning, tools that you can use, and the process of estate planning.
So first off, let's just get basic. What is estate planning? Estate planning is a process that allows you to control your property while you're alive and well. It also is an opportunity for you to plan for you and your loved ones should you become disabled or upon death. The goals of estate planning are really the why and the what of your estate. It gives you time to determine who you want to have what you have, when you want them to have it, and the way that you want it done. And a lot of times you look at the lowest cost option for you and your family. It's a way to incorporate a balance of your financial, social, emotional, and spiritual aspirations, if you will, that have been important to you during your lifetime. Basically, you've worked hard for what you have. You want to be sure you know where it's going, where it's going to go, where it has been, and who you want to have it.
Thanks, Derek. So how do you start the estate planning process? The first step in the estate planning process is to establish the boundaries of your asset, your estates. The important areas to document are those assets. So you look at your assets and consider cash, retirement accounts, real estate, stocks, life insurance, an interest in a business, any other assets you may own, and marshal those assets or pull them all together and document what they are. You need to check how your assets are owned. Are they owned in your name? Are they owned jointly with right of survivorship? Are they owned as tenants in common? And then where are your assets located? Document the geographic location of all of your assets. Document the location of your real estate, the location of your safe deposit box, any brokerage accounts listed where stocks and bonds are held, and also list out where you keep your important documents and policies. And then what is the value of your assets? It is important to have an estimate of the value of your assets. So you have an estimate of the total estate value to ascertain the most effective form of planning and the most cost effective, as Derek noted. It is helpful to have an appraisal of your real estate, but a county appraisal may be enough. Marshal those brokerage statements. What are the face values of your insurance policies? What are your retirement plan assets? And list the debts that are owed on any of those assets or other debts as appropriate.
Once you have this asset list put together, the thought process is, who do I want to have my assets and what do I want to do with them? One of the first things you should do is establish your beneficiaries. Your beneficiaries, for most of us, are pretty simple. Family members, spouse, children. Beneficiaries can also be, however, nieces and nephews, grandchildren, and those mentioned specifically for who you want to have what you have. You can also make a list, as far as beneficiaries, of charitable organizations who you would like to benefit through a lasting lifetime gift. You can consider also, and you should consider, executors of your estate. These are the people that will take care of paying bills, taking care of the assets themselves. If you don't have someone you can trust to do that, you can actually have a bank or a trust company listed as an executor too, as a beneficiary. And also consider any minor children or maybe children with any kind of disabilities that you may have or special needs that you may want to establish a guardian for them as well as far as beneficiaries go.
The second step in that process is to evaluate what tools are useful in making sure that your assets and your beneficiaries are protected. I'm going to talk a little bit about some tools under Kansas law, but I will try to mention if those are available under most states, and as always, it's important to note you should contact your own attorney or advisor in the case of any estate planning that you're doing, wherever you may be located. So under Kansas law, we have joint tenancy with right of survivorship. A joint tenant has the right to take ownership of the property upon the death of the owner without probate. Under Kansas law, that person can take ownership without going through any kind of legal process. When joint tenant passes away, the second joint tenant with right of survivorship becomes the owner of that property. According to my research, that is available in all states, but some states do have some specific procedures and rules under joint tenancy. So again, it is important to contact your own attorney or advisor to make sure that this is covered under your state's laws. Beneficiary designations are an important non-probate process that you can avail yourself of. Life insurance policies, 401k plans, 403b plans, retirement accounts like IRAs all have a beneficiary designation that you can utilize to have a beneficiary of that account when you pass away without probate. In Kansas, there's also a law called payable on death beneficiary, where you can name a payable on death beneficiary on bank accounts. This beneficiary will be able to take ownership of the account at death, but they do not have any ownership accounts in that account during your lifetime. So they're not available to attach to creditors, for example, if something were to happen to the estate of your payable on death beneficiary, a lawsuit, for example. There would be no ability for that money to be attached because they do not have ownership during your lifetime. Again, this is available in most states, and check with your attorney, but it is definitely a really useful tool to avoid probate. If you have a beneficiary that you want to have access to your accounts during your lifetime to pay bills, etc., you can add them as an authorized signer. And then finally, in Kansas and 28 other states, there is a provision called transfer on death beneficiary, which can be used on brokerage accounts, real estate, and automobiles. And that's the same kind of process as payable on death beneficiary. That person does not have any ownership of those accounts during a lifetime, but would get it on death. And again, that is available in 29 states, including Kansas, and important to consult your expert advisor.
Exactly. So as you can see, there are many ways to move your property and your assets to pass them to the desired beneficiaries without having to go through the probate process. However, as Janet mentioned, when you set these things up, you should always contact your own attorney to discuss all of your options, the assets, the beneficiaries, etc. So there are other things to consider that may not be taken care of with these beneficiary designations that Janet just mentioned. One of those most important documents people think about is having a will. And a will is basically a written document, usually drafted by an attorney, that carries out your wishes upon death for your assets. A will is very important. You get to name the executor, someone who will take care of everything for you, maybe guardians for minor children and disabled children. You can do tax planning with a will. And again, the charitable organizations that we talked about earlier to maybe make a lifetime transfer, of your assets upon your death. The will itself has to be submitted for probate in the county where the assets are held. And if you don't have a will and things aren't taken care of with your beneficiaries, the state will determine where things go through intestacy. Not really the best option, but it is an option. That's why a will is so important. Another option to have is called a living trust. A living trust is a way to take care and move things while you're still alive, but they're owned in the name of the trust. The trust then becomes the owner of those assets. You can designate the executor or the trustee, if you will, of the trust, and a lot of times the person who owns the property, you can name yourself as the trustee. So therefore, you're in charge of these things as the trustee through the living trust. And then you can name, of course, your successor trustee. This is a way that your assets do not have to go through probate because the successor trustee takes care of the trust at that point. So trust owns the assets. They can be taken care of that way. But again, before doing any of this, you should consult an attorney to know all your options, be sure all the paperwork is drawn up correctly.
Finally, just to talk a little bit about some documents you can use to protect yourself in case of incapacity. There's the durable power of attorney. Is a document, a written instrument that authorizes another person to make decisions for you when you are incapacitated and unable to make decisions for yourself. And usually there is a provision in that document that there is a letter required from a medical professional that attests that this person is incapacitated. This usually applies in financial matters, and then the validity of a power of attorney ceases at death. It is critically important to carefully consider who you name for this position because of the importance of the task. There's also a power of attorney for healthcare decisions. This document is a written instrument that authorizes a person to make medical decisions for you in the event that you are incapacitated. And also very critical to consider who you would name, because it is indeed a very important task. Finally, there's also the living will. That documents your wishes about prolonging your life through artificial or extraordinary means in the event of serious illness. You should discuss your desires in all of these areas with your attorney, your doctor, and your family to make sure they are comfortable with the decisions that you've made.
Many times when we talk about estate planning, a lot of people have to put these documents and these things together at a difficult time. Maybe a family member has become disabled or things of that nature, or passed. If you do this ahead of time, you're giving not only yourself the gift of knowing how things are taken care of, but your family as well, and it's very important. So if this is not something you've thought about, that's why we wanted to share this series with you, so you would think about these things and have things in place for you and your family.
Thanks, Derek. This is part one of our estate planning seminar, where we talked about process, tools, and how to start estate planning. Part two, we would like you to join us next time for advanced estate planning and charitable planning, and the benefits of each. We also want to let you know that we have a planned giving website as a part of the ottawa.edu website, and we have, as a part of that, a comprehensive estate planning kit that you can download, and it will help you protect your loved ones, organize everything, and put it in one place, and possibly even save on taxes. And we will show a slide at the end to let you know where you can access that website and to learn more about planned giving. It is ottawa.myplannedgift.org. So thank you very much for your attention. And again, if you have any questions, you can also feel free to email us personally. You can get me at janet.peters@ottawa.edu.
And I'm at Derek, DEREK, .chappell, CHAPPELL, @ottawa.edu.
Thank you.